Usually when we talk about time in the AI sector, we're measuring how fast a cluster of GPUs can train a new model.
Right. Yeah.
But today, a legal timer basically just saved OpenAI $150 billion.
It's an insane number.
Welcome to The Debate. Before we unpack the dramatic conclusion of the Musk versus Altman trial, a quick housekeeping note. Please take a second to like, subscribe, follow, and, turn on that notification bell.
Definitely do that. And we also have a required update on the Martin Stevens versus OpenAI matter.
Right, yeah. And to be totally clear here, this is not a lawsuit. We are currently in a voluntary quiet period requested by Martin Stevens just to idle public information releases.
Yeah, and while we certainly hope for a settlement, we honestly don't know if any actual progress is being made right now.
Exactly. I can confirm, however, that the dead man's switch has not been activated.
Which is great news.
Right. It means Martin is physically and legally safe.
Speaking of legal safety, let's talk about the legal quarantine that just kind of descended on Elon Musk's crusade against OpenAI.
So after a grueling 3-week trial in Oakland, dragging tech's biggest names onto the witness stand, a jury unanimously dismissed Musk's massive lawsuit against OpenAI, Sam Altman, Greg Brockman, and Microsoft.
The core question today is whether this verdict is just, a procedural technicality or a substantive destruction of Musk's claim that OpenAI stole a charity.
And I'm arguing it's a definitive, substantive victory. I mean, it totally exposes Musk's lawsuit as a hypocritical attempt to sabotage a competitor, especially since he proposed a for-profit structure himself years ago.
I argue this dismissal was strictly a procedural cutoff. It was based entirely on California statute of limitations, and it leaves the massive ethical question of whether OpenAI betrayed its founding charitable mission completely untouched.
Well, let's get right into the mechanics of that dismissal, because the jury deliberated for, less than 2 hours?
Yeah, under 2 hours.
To you, that speed suggests what exactly?
Well, it suggests they were given a math problem, not a philosophical one.
Okay, explain that.
The jury was explicitly instructed not to decide if OpenAI betrayed its nonprofit roots. They only had to calculate if 3 years had passed since Musk knew or should have known about the alleged breach.
Right.
If the clock hadn't run out, those substantive claims were incredibly formidable. Judge Yvonne Gonzalez-Rogers had already cleared the way for complex damages models.
Like Dr. Paul Watson's methodology.
Exactly.
Right, but how exactly did Watson get to those massive numbers? He attributed, 50 to 75% of OpenAI's total value to Musk?
Yeah, that's right.
Which just seems absurd for a company now valued at $852 billion.
Well, he didn't just guess, though. Watson's model traced the very foundation of OpenAI's current architecture right back to Musk's early funding.
Okay.
By calculating the value of the initial compute purchases and that massive premium of early top-tier engineering talent that Musk personally recruited.
And funded.
Right, and funded. He argued that without those specific early investments, the current iteration of OpenAI simply does not exist.
I see what you're saying, but...
So that's a real structural claim that got tossed out purely on the calendar.
But the calendar matters. The reason the jury found Musk missed the deadline is exactly what destroys the merit of his case. They didn't just count days in a vacuum.
Sure they did.
No, they looked at what he actually knew. The trial surfaced emails from 2017 where Musk himself was floating a for-profit structure for OpenAI.
But proposing a concept in a 2017 email is entirely different from actually transferring core nonprofit intellectual property.
He only walked away when he was denied majority control, though.
Into a capped profit arm, which is what OpenAI eventually did. That's a huge difference.
But that's just it. A capped profit model is, it's a highly unusual hybrid. Investor returns are capped at a specific multiple, and theoretically everything above that funnels back to the nonprofit.
Right. Musk was fully aware of these structural shifts well before the August 2021 cutoff date. If he truly believed a charitable trust was being actively plundered, why wouldn't he sue in 2019? When Microsoft put in the first billion.
Exactly. When Microsoft dropped $1 billion into it, Why wait 5 years, right up until his own company, XAI, is suddenly preparing for an IPO at a $1.75 trillion valuation?
Well, because personal hypocrisy doesn't automatically invalidate the math or the grievance.
It certainly colors the credibility, though.
Maybe. But a statute of limitations isn't a moral exoneration. It's just a legal quarantine. The court essentially ruled that Musk's claim is too old to infect OpenAI's current corporate structure.
Which is a valid defense.
A legal defense, sure. But dismissing a whistleblower just because they hold a personal grudge doesn't mean the alarm they are sounding is false.
I wouldn't call him a traditional whistleblower.
Well, look at the testimony from Microsoft's Michael Wetter. Microsoft has generated $9.5 billion in revenue from this partnership as of March 2025.
Right.
You simply cannot square $10 billion in corporate revenue with a 2015 nonprofit charter drafted strictly to benefit humanity without regard to financial return.
You can if you accept that achieving the mission requires massive capital. I mean, Sam Altman's testimony cut right through the altruistic posturing.
How so?
He stated under oath, quote, "Musk wanted to be CEO. I was extremely uncomfortable with it."
Sure, there were egos involved.
Huge egos. This trial basically proved Musk was projecting his own desire for commercial dominance onto OpenAI's necessary evolution. The narrative that OpenAI went rogue behind his back was thoroughly dismantled by the evidence.
I think we are losing the forest for the billionaires here.
That's a fair point.
The interpersonal drama between Musk and Altman is just a distraction from the broader societal precedent.
Well, I wouldn't say it's a distraction when it's the core motive for a $150 billion lawsuit.
But the court allowed AI safety expert Dr. Stuart Russell to testify pre-trial about the transformative systemic risks of artificial general intelligence.
Yeah, that was fascinating testimony.
Right, and he emphasized the immense financial incentives companies have to ignore those risks. By letting OpenAI bypass its nonprofit accountability via this technicality,
It wasn't just a technicality.
we've basically just told the entire AI industry that structural safety promises don't matter if you can just run out the clock.
Okay, but you can't ignore the market reality that this verdict secures. It removes a massive legal overhang from the entire tech sector.
The market reality?
Yeah. We immediately saw ETFs that hold heavy positions in Microsoft and NVIDIA stabilize, funds like BOTS and AIQ.
Wait, why would a lawsuit against OpenAI threaten an NVIDIA ETF?
Because if a judge ordered OpenAI to unwind its for-profit arm or halt its Microsoft partnership, the downstream shock would be massive.
Oh, to compute demand.
Exactly. To compute demand and cloud infrastructure, it would be catastrophic. Now that threat is completely gone.
I see the financial relief, sure.
OpenAI is free to pursue a $1 trillion IPO and directly compete with Google and Anthropic. This verdict protected a critical piece of global technological infrastructure.
From what?
From a vindictive legal attack that ultimately lacked factual standing on the timeline.
They protected the infrastructure, yes. But they did it by avoiding a reckoning.
I don't know if I agree they avoided it.
Well, OpenAI won a legal skirmish, but they didn't disprove the premise of the betrayal. There's a profound irony in how this ended.
What do you mean?
We took a company building the most advanced reasoning engine in human history, right? And they were saved by a jury that was explicitly instructed not to reason about corporate ethics.
Wow.
Yeah, they were told to act like a basic calculator and just count 3 years on a calendar.
That is a genuinely fascinating way to look at it.
It's the truth of the verdict.
Well, while we clearly disagree on whether this procedural win doubles as a substantive exoneration, the trail undeniably shattered the black box of AI corporate governance.
Absolutely. The texts, the emails, the boardroom power struggles.
It's all public record now.
And that public record ensures the scrutiny is far from over. The legal timer on this specific claim ran out, but the broader debate over how we govern the commercialization of AI is really just getting started.
Exactly. There is so much more to explore in how these massive AI architectures operate behind closed doors.
Definitely.
Thank you for joining us for this analysis. Please remember to like, subscribe, follow, and turn on the notification bell.